Swayam Prabha. Digital India. Educated India.
My greetings to all of you. I welcome you all in this lecture, and this lecture is based on the paying banker. So I am Dr. Raju Maji, Assistant Professor, Faculty of Law, Banaras Hindu University. I welcome you in the lecture series, and in this lecture we will discuss about the paying banker and its statutory protection. Now, what are the scheme of this particular lecture? In this lecture, we will discuss that we will try to get the answer from question. The first question is, who is the paying banker? And the second is that what are the statutory protections has been granted to him? And the third, unless and until we know that what are the functions of the paying banker, we cannot find or we cannot get the answer that the legal protections which is or statutory protections which is granted to the paying banker. So, dear students, with this background, I would like to recall the certain things which we have discussed in the previous lecture. The previous lecture, when we talk about that, the collecting banker, at that time we have discussed that every bankers, they are acting as a collecting banker as well as they are acting as a paying banker. Now, that we have already discussed that the collecting banker means when the banker is collecting an instrument, particularly the check, and the check which is issued by the customers or the customers when he receive from someone else, and that is the cross one, only one means is available before the customer, that he has to deposit before the banker to encase or get payment. That when the bankers is receiving that, the banker's duty is that he will collect that. That is why we are calling it the collecting banker. On the other hand, that this lecture is based on that the paying banker. Now, as we have seen that the banker, when he is collecting the check for its customers, we are designating as he is a collecting banker. In the same way that when we are trying to get the answer that who is the paying banker, so naturally answer is that the banker who is performing or the banker upon whom the duty to pay the amount of the check is imposed is called the paying banker. But the situations are different. As I have mentioned earlier, as far as concerned the collecting banker is collecting money for its customers. Why? Because due to the nature of check. Similarly, that the paying bankers will also do that. Why? Because the similar you can say the circumstances. What are the circumstances? When the customers is presenting a check for encase before the paying banker is making payment of that. That is why we are calling it he is the paying banker. When the paying banker is discharging its obligation, naturally the paying banker will also ensure some of the technicalities which is required to be ensured, so that the payment can be made in the right way, in a proper way or in a proper manner. That is the answer we are getting, that who is a paying banker. The answer is that the banker upon whom the duty to pay the amount of the check is imposed is called the paying banker. Now, the paying banker is the banker to whom the order to pay, where the order takes the form of a check, is addressed when a person opens an account with a particular branch of bank. The contractual relationship of banker and the customer starts. Now, see, as we have seen that the bankers, when he is making the payment, so banker has to ensure. So, naturally that some of the liability which lies towards the paying banker, and these are the liabilities of the paying banker. He has to discharge the duties before making any sorts of the payment. Let us see what are the liabilities which lies towards the paying banker. The obligations of paying banker is to beg the money to his customer or his endorsee is not absolute but conditional. That means every check which is presented before the paying banker is not liable to pay it. The reason behind it, because he has to ensure that the payment must be made to the right person, to the correct person. The persons, either he is the maker, persons either if he is presenting the check himself, the maker can be present himself, or it is presented by the endorsee. That has to be ensured by the paying banker before making the payment. The obligations of honoring checks has been imposed on him by section 31 of the Negotiable Instruments Act 1881. Again, I would like to recall you, as many times I have stated, whenever we are talking about the relationship which begins, whatever may be the, as we have discussed earlier, that I have told you that the status of the customers is unsecured creditor, but it doesn't mean that unsecured means your money is not secured. Why your money is secured? Then we can relate that particular with the section 31 of the Negotiable Instruments Act. If we will see, dear students, the Negotiable Instruments Act of 1881, section 31 imposes obligations towards the paying banker. And what is that? Let me allow to read out. The provision says that the drawing of a check having sufficient funds of the drawer in his hands properly applicable to the payment of such check, pay the check when duly required to do so, and in default of such payment must compensate the drawer of any loss or damage caused by such default. Again, I am repeating it. It's a very important provisions that only one section which imposes obligations towards the paying banker, and the paying banker has to discharge that obligations because it's the public money, as we have already discussed. So, it is talking about the drawer of a check having sufficient funds of the drawer in his hands properly applicable to the payment of such check, pay the check when duly required so to do, and in default of such payment must compensate the drawer of any loss or damage caused by such default. As again, I would like to reiterate here, that is the obligations which will be imposed under section 31 of the Negotiable Instruments Act. That is, as the amount which is available in terms of the sufficiency of fund, it is the paying banker's obligations that he has to honor the check which is issued or which is presented by its customers for getting the payment in respect of that particular check. Only his duty is to ensure that the check is issued in a proper way, and that when he got that the check is used in a proper way, the check amounts which is mentioned there, that is in a equal value of the amount, it is available in the customer's account as a credit. If the credit amount is available in the customers, there is no reason to deny it, there is no reason to dishonor the check, and it's the responsibility lies towards the bankers that to honor that according to section 31 of the Negotiable Instruments Act. But again, I would like to recall that, as I have told you, that if it is required to do so, that means it gives an opportunity, or that the privileges is available, or the discretion powers is available to the banker, that whether he will honor or not. But there is no questions about, by reading that provisions, that it is the liability imposed towards the paying banker that he has to pay. But there are certain circumstances where the payment will not be done by the paying banker, or in other ways say, the circumstances under which the duty of paying banker to honor check can be enforced. What are these? These circumstances are: a banker is bound to honor his customer's check to the extent of the funds available and the existence of no legal bar to payment. I will come to that point. The second one is, the instrument should be in writing. The third condition is that there should be an unconditional order to pay. The fourth condition is that it should be payable to the bearer or to order. The fifth one is that the pay must be certain person or persons. And the sixth one is there should be a signature of the drawer on the check. And the seventh one is that a check is payable on demand, hence a demand should be made to the banker for its payment. And finally, the 8 talk about that the check must be in order and must be duly presented for payment at the branch where the account is kept. Let me explain one by one. As I have told you that these are the circumstances under which the duty of paying banker to honor check can be enforced. In other way we can say these are the technical grounds as far as concerned for the honoring of a check. Although that the duty has been imposed under section 31 of the Negotiable Instruments Act 1881 towards the paying bankers that he has to honor the check, but if he will find any in the circumstances then he will not honor it. The first one is, it is talking about a banker is bound to honor his customer's check to the extent the funds available and the existence of no legal bar to payment. Here I would like to mention 2 instances. The first one is, if you will see if there are insufficiency of fund, naturally the bank will not honor it. So, to honor when it is important, or you can say when this duty can be discharged by the paying banker, if there is a sufficient balance in the hands of the customer's account. In case of the insufficiency, there is no questions about that the banker will honor it. Banker will dishonor and he will return with the remarks whatever may be the reason behind it. But the second circumstances which I would like to mention here, that it is talking about the existence of no legal bar to payment. What do you mean by the existence of no legal bar to payment? That by any authority there is no any kind of, you can say, the restrictions, or you can say that it is restricted or a stop for the payment. Sometimes we find that the customer itself, by sending instructions to the banker itself not to honor particular check, in these circumstances it is not honored by the banker. And the same time we will find that if from the income tax authority, or if any investigating authority which is empowered to issue such kind of the directions towards the bank, and the bank has, it is mandatory towards the banker that he will follow that instruction. Particularly I will take the name of that, where the court issue a garnishee order at that time, unless and until the garnishee order is completed, the paying banker will not exercise its duty which has been imposed or which is expected under section 31 of the Negotiable Instruments Act. That is the legal bar. If in case of any legal bar is there, or the legal bar here means that if it is stopped by any of the authority who is empowered to issue directions to the courts will obey, or courts will it is mandated before the court. The instruments should be in writing. Now, suppose if you have sent a persons by mentioning that and giving instruction through the telephone that you pay the some sort of amounts to XYZ, he will not pay, because that it is not made in a writing. So, the writings, again we are talking about the proper manner. The proper manner, as I have told you, that the customers must have that check in his own name, which is issued by the banker at the time of opening an account, and only on those checks the customers is entitled to issue an order, or you can say that make an order as a drawer of that instruments. He must put his signatures also. When this, as far as concerned, the next one, when we are talking about there should be an unconditional order to pay. The instrument which you particularly check is Negotiable Instruments Act, negotiable instruments under the Negotiable Instruments Act under section 13 of the Act, and it is specifically defined under section 6 of the Negotiable Instruments Act. We will discuss later on in the latter part of the lecture in details. But at present, just I would like to mention that you cannot put any kind of the conditions when you are issuing that unless and until only that the endorsement can be made, and the remaining part under the check you cannot put any kind of the condition. So, that when you are issuing the check, there must not be any sorts of conditions to be put by the maker or by the assignee, or you can say the endorsee. Only that can be made as far as concerned how the payment will be made, that can be done. Then it should be payable to the bearer or to order. Now, that, as I have told you, when we are crossing the check, you are seizing the power of the paying banker. Now the paying banker is not entitled to honor it. Only the collecting banker can do that, because you have crossed that check. So the character of the check, that must be continue with the bearer or to order, so that when other persons will present before the concerned branch, the branch can enable to make payment, or that the payee can get the payment through the paying banker. Then it is talking about the pay must be in certain persons or persons, that even if the makers, when he is issuing a check, he is issuing by mentioning the name, that name must be the certain one. If under the instruments, means under the check, if you are not mentioning the check, then the payment will not be made. But sometime that's what we are doing, that when the maker itself, or you can say the drawer itself, is a payee, then he is writing the name, he is not writing in the check, he is mentioning the self. Or whenever you are instructing to the bank to get payment for certain purposes, then we are using that the myself. So the bank or the drawer can do like this. In remaining cases, it's the person's name or must be certain one, that who is going to get the payment, and the paying banker will follow that instructions only. Then it is talking about there should be a signature of the drawer on the check. Now it is one of the very important features when other persons is issuing a check. If every content which is required, as far as concerned the check, there are only 3 or 4 things which is required, that if you go through the check leaf, then you will find the first, you will have to write the date, the second you will have to write the name of the persons to whom payment is going to be made, that we are calling the payee, and the third one, the amount that must be mentioned in words as well as in figure. Apart from that, there will be a signature of the drawer. So without signature, that the instrument is the meaningless, and that will not be executed by any means, because unless and until the drawer is putting his signature on that instruments, it has no effect. There is no any kind of the legal effect on that document. So the signature played a very significant role. When it is putting that signature, then the other hand, it is the duty of the paying banker at the same time that he will ensure that it is exactly the signature which is available at the time of you can say opening an account. In the specimen signature, he has to verify that, as I have mentioned earlier also. Again, I would like to recall you, nowadays it is very easy. As soon as that your account number is putting, automatically it will display in the computer screen. That is the what we call, that is the ledger folio. Automatically it will comes along with your all the details, where your signature will be appears in this computer screen. So the persons who is certifying that whether the instrument is issued by the customer himself or not, or it is the forged one, that has to be verified, and with that verification the payment will be made. So the signature, if it is not signed by the drawer, then there is no value. Even if in the later part, if the endorsee is putting its signature, there is meaningless. The maker's signature is one of the very important. Without having the maker's signature, the instrument has no value. Then check is payable on demand, hence a demand should be made to the banker for its payment. As we know that only the bankers where we can make a demand, and the demand means it is in an order form, and check, when we will discuss the check, then we will find check is in order. The order, when we are talking about that, the order can be made when there is a pre-existing relationship between the banker and customers. What kind of the relationship between the banker and customers? When we can say that it is an order? Because the creditor has a right to ask his debtor to pay. So he will make an order, because the debtor owe his money. That's why the creditor have that rights, And in the normal cases, as I have told you, when the bankers is accepting the deposits of the customers, the relationship automatically commence, and that relationship is bankers become the debtor and customers become a creditor. Being a creditor, the customers will issue a check, and it is obligatory on the part of the paying banker to honor that as far as concerned section 31 of the Negotiable Instruments Act 1881. And that when the demand is made, the demand is being made in a proper way. That is very important. The proper way, when we are talking about, that means it must be presented duly the prescribed, you can say, the banking hour, as well as it must be presented in the concerned branch. But of course, and the new or you can say the new thing has been introduced as far as concerned, the concerning or the honoring of a check due to the various kind of the checks. So, the multicity check we have, and on if it is a multicity check, that empowers the persons or the industry who can present or who can get the payment from any of the its concerned branch. It is not necessary that the check must be presented with the concerned branch. In any branch, it can be in case subject to if the check is multicity check. Then finally, it is talking about the check must be in order and must be duly presented for payment at the branch where the account is kept, which I have already discussed with you. The paying banker should use reasonable care and diligence in paying a check, to abstain from any actions likely to damage his customer's credit. If a paying banker wrongfully dishonors a check, he will be asked to pay heavy damages. At the same time, if he makes payment in a hurry, even when there is no sufficient balance, the banker will not be allowed to debit the customer's account. If he does so, it will amount to the sanctioning of overdraft without prior arrangement. Now, the two things which I like to mention here. The one, as I have already mentioned before you, that as a paying banker, when he is making the payment, he has to take utmost care, due diligence. He has to ensure the check is issued in a proper way. The signature must be verified at the time, at what time it is presented, whether it is presented in the right branch or not, each and everything. If the bankers acting hurriedly, and even if there is insufficiency of fund, if the banker mistakenly, if he made payment, the bankers is going to lose it, and bankers cannot charge the overdrawn over it, or you can say any kind of the surcharge over that. And it can be understood by the customers that the banker accept is the overdrawn facility. And as I have told you earlier also, that the overdrawn is another kind of, you can say, the arrangement between the banker and customers, where the banker is determining the insufficiency of fund that has to be taken into consideration. Again, for your ready consideration, what I would like to mention here, as I have told you, the insufficiency of fund will be determined in the two way. The way is that there must be sufficient credit balance in the customer's account. That is the first one. And the second, in absence of that, if there is less amount, but if there is arrangement between the banker and customers, what is that arrangement? That arrangement is called the agreement between the banker and customers, that is to allow the overdrawn facilities. To that extent, if, for example, if in a particular current account, if the bankers permits the customers to overdrawn rupees 1 lakh rupees, so if there is zero balance in his account, the amount will not be, or you can say check will not be written, or check will not be dishonored unless that the limit which has been prescribed under that agreement, or we are calling it the arrangement between the banker and customer, that is 1 lakh rupee, that has to be taken into consideration. And if the bank hurriedly act anything like this, and if any loss or damages occurred, the banker has to penalize, or the banker has to compensate its customers. Now, the second precautions which is very important, it is the precautions to be taken by the paying banker, consideration which a paying banker should bear in mind before honoring the check. The precautions which a paying banker should take before honoring a check are nothing but the duties of a paying banker. In order to safeguard his position, the paying banker has to observe the following precaution. as again and again, and many times I have reiterated, whether it is a collecting banker or whether it is a paying banker, there are certain duties which has been imposed, and these are the precautions you can say that the bank must take, and unless and until the bank is doing his work according to the duty which has been imposed, the privileges, or we can say the statutory protections or the legal protections which is available to the in any form, whether the collecting banker or the paying banker, the banker cannot exercise that rights that can be exercised by the bankers when he is performing his duty. As far as the paying banker, that its safeguards which is available, to get that safeguards, he has to observe the following the precautions. The first one is presentation of check, the type of check, branch, correctness of form, date of the check, account, amount, Hindi language, mutation, material alteration, banking hours, sufficient balance, signature of the drawer, endorsement, legal bar, minor precaution. Again I am repeating it, there are the various precautions has to be taken by the paying banker, which a paying banker should bear in mind before honoring a check, and these are the presentation of check, type of check, branch, correctness of form, date of the check, account, amount, Hindi language, mutation, material alteration, banking hours, sufficient balance, signature of the drawer, endorsement, legal bar, then minor precautions. Now see, when we are talking about that, these are important as I have discussed, but again I would like to say the certain things that what is required, what are the precaution. As a paying banker, the first he has to see that whether the check is presented in a right way or not. That is very important. Now when we are talking of the presentations of the check, that means that we will have to ensure that type of the check. When we are talking of the type of the check, as I have told you that the cross check that is not a part of the paying banker. If it is a cross one, it is a part of the collecting banker. So you will have to, first and foremost thing, you will have to see if the check is cross one, whether it is generally crossed or especially crossed, it does not matter. Immediately it has to be ignored by the paying banker, because paying banker is not entitled to pay that. So the presentation of the check. Then as the type of the check, you will have to see that what is the type of the check, whether it is a cross or uncrossed one. Then the third one is the branch. As I have mentioned that the check must be presented in the branch from which branch it was issued. The other way we can say where the customer's account is lying, or in which branch the customers have its own account. In that branch it has to be presented, but unless we can say that if there is the multi-city check is there, then it is not required to present in the same branch. In the remaining cases, it's his duty that the check has to be presented before the concerned branch. The correctness of form. When we are talking of the correctness form, again we will have to check all the things. What are the ingredients of check? As I have pointed out that the person's names must be appear in that way, what names are exactly mentioned in his account. It is not your presumptions or it is not your understanding that X, Y, Z, or the, for example, that if I am taking one example like Sita. Sita can be write S-I-T-A and Sita can be write S-E-E-T-A. It does not matter that what is wrong or right. What is important that as a maker, when you are giving to any persons, you will have to write his name in a correct way. Otherwise, the banker will not accept it. So, when the banker will not accept, when the bankers will take it very, you can say, minutely, and he will see that the error of the you can say the page name, he will deny it. So, you will have to see the correctness. And the date of the check is very important. As yesterday I have told you in the previous lecture, again I would like to mention here that the date of check is very important. There are the check may be the predated or maybe the post-dated. In both the cases, the bankers will not accept. In predated, if there is a predate or the post-date, whatever may be, the check has no, you can say, the value unless and until it is presented during its specified valid period. And the valid period at present what we have, that is from the date of issuing, within 3 months you have to present before the bank. Now, the account, the nature of account is very important, that the customers, if the customers having a deposit in the bank, and that is the recurring one, and because the recurring deposit account is there, so when he receive any kind of, you can say, check, and if he wish to deposit that, that cannot be deposited. Why? Because the recurring is the different kind of account. The recurring account is the account where the persons is depositing its day to day, you can say, the some sort of the amounts, and in a after any fixed period which is determined at the time of opening that recurring, that may be the 1 year, 2 years, 3 years, whatever may be, it depends on the customers to what extent he wishes to deposit it, and after the maturity of that period he will get back that money. But in that account the check cannot be deposited. So, the nature of the account has to be vary. You will have to see that whether the account is the current account or the account is the saving accounts. Only these accounts the check can be accepted. The amount is very important. As earlier I have mentioned that in the previous lecture we have discussed that the amounts, as far as concerned the Negotiable Instruments Act which we have seen, the one thing which I have seen, that in case of the mismatch, it is the duty of the banker immediately has to return it. But as far as concerned that some of the practice which has been mentioned, or it is mentioned under the Negotiable Instruments Act, that suppose there is a mismatch, then if the bank wishes, then he can make payment of the amount which is mentioned in words. But if there is no any kind of, you can say, the amount is mentioned in the figure, but amount is mentioned in the words, then again it is also mentioned that the payment can be made the amount which is mentioned in the words only. So, but as far as concerned the general practice, as I have told you, that the bankers will return it by making the remarks that there is a mismatch of figures, a mismatch of amount in figures and words. So, that is very important. As far as concerned the language of Hindi, it is very important, because most of the time we will find that when the person is opening an account in the bank, then you will find they are not mentioning the name in Hindi. But if in the Hindi it is written, and if the check is issued in that name, now it is very, you can say, the critical situations before the banker, if he wishes to check the spelling, as I have told you, if the spelling differ, the bank will not accept. But now when the check is issued in the Hindi, and in our country that it is issued in Hindi, then it cannot be denied to the banker. In that circumstances, he will ensure that whether it is issued in a proper way or not, and he will see that how it is written, and he will ensure by signature of the endorsee or the endorser, or you can say the payee who is putting his signature on the back side of the instrument. On the basis of that, the bank will certify and he will make payment. Now, the mutation and material alteration, that is very important, as I have already mentioned before you, that any source of alteration, it must be ignored by the banker. In either way he is acting, whether he is acting as a collecting banker or he is acting as a paying banker. It is the better that if there is, if he found that there is any kind of alteration is made, whoever may be, whether it is made by the endorser, or if it is made by the payee, or if it is some kind, you can say, the corrections has been made by the maker or the drawer himself, it does not matter. As far as concerned that section 10 of the Negotiable Instruments Act is talking about in what manner it appears before the banker. If the banker find that there is the alteration is there, correct, that some sort of you can say overwriting is there. So, the bankers is liable to return it, and if he is accepting in that condition, then according to section 10, which is talking about that it must not be accept, and if the banker is accepting it, the liability lies towards the banker, and if any loss occurred or the damages occurred, the bankers has to compensate that loss or the damages. One of the very important aspect, that is the banking hours. The banking hours, when we are talking about that, it is mentioned the Negotiable Instruments Act that bank for the public, there is a specific hour which has been mentioned, and it is notified by the banker, and it varies from place to place because due to some region. So, whatever may be which is notified by the banker itself under the Negotiable Instruments Act, that will be treated as the banking hours as for their own convenience, and within that banking hours the customers has to present that check if he wish to get payment. And the next precautions, as I have told you, the sufficient balance, as we have already discussed, that it is one of the very important aspects as far as concerned the paying banker. The paying banker has to check that whether the sufficient balance is available in the customer's account or not. If it is not available, or the arrangement which is available to the customers, that amount exceed, in that circumstances he must return the check without making any sorts of the payment. Signature of the drawer, as I have told you, that is one of the very important, in the aspect that sometime I am telling you that check may be, if you are putting, and the check may be issued without mentioning the amounts, without mentioning the name, which we are calling the blank check. The blank check, it does not mean that you are giving the leaf to the someone. That will not call the blank check. Blank check will be called when the maker is putting his signature in the place where the signature is required, and he is giving someone, he is transferring, he is handed over to someone else, that will consider as the blank check. In the remaining cases, if you are having the leaf blank, it does not mean that it is the blank check. The blank check means where the maker is putting his signature and he is not fulfilling the other you can say the ingredients which is required to be filled up by the maker. Then the endorsement is very important. So, the endorsement we will discuss in details, we have a separate chapter, but the endorsement where is one of the, you can say, the significant characteristics of negotiable instruments. Negotiable, it does not mean that to negotiate. Negotiate means it is a transferable from one hand to another hand. So, the endorsement have that. The endorser and the endorsee, they will as many numbers except the payment has been made or the maturity period expires. Within that period, particular instruments may be passed through the several hands. That is the beauty of the negotiable instrument. The check can be, if it is bearer check, that can be passed through the several hands, and that can be done through the help of endorsement. Then very important things, as I have already mentioned, the legal bar. You will have to check that if any kind of, you can say, the restrictions or the legal impositions which barring the banker to exercise his duty or to dispose of his you can say the obligations towards the customers by the legal bar. As I have cited one example, for example like this, the banker received what the banker received, that is the garnishee order from the court. So, the bankers will not entertain any kind of, you can say, the instrument which is issued by the customers in his account, and that the minor precautions as far as concerned, that the bankers has to see whether the things as far as concerned the section 10, the apparent tenor, the signature, or you can say the other technicalities which is required, that has to be take, and the bankers has to examine before making the payment. The third part which we will discuss about the statutory protections to a paying banker. They are the various sections which deals about the protections of a paying banker. It is not like the collecting banker where we have discussed that there were only one section, that is section 131 which empowers that the collecting banker is not liable subject to if he has compliance his work accordingly. So, in the same way that the statutory protections to a collecting banker is also provided, and it is talking about that payments of checks involve risks to the paying banker because the latter must pay the amount of the check to the right persons according to the instructions of his customer. If he makes payment to the wrong person, he will bear the loss. The banker has to honor his customers' checks on demand, and hence he cannot make detailed inquiries about the title of the persons who presents the checks for payment. Now, one of the very, you can say, the crucial the points before the banker that how to check that whether the persons is entitled it or not. The titlement is always a very crucial subject matter before whether he is acting as a collecting banker or he is acting as a paying banker. So, when he is acting as a paying banker, the payments of checks involves risk, as I have told you, that the paying banker, because the letters must pay the amount of the check to the right persons according to the instructions of his customers. The customers, when he is issuing, a person who is presenting, neither he can ask, but if he will see that the bankers is doing that very cautiously, but if there is a lesser amount is there, the bank cannot do that. He will not exercise. But as my concern, when there is a huge amount in any check, then the bankers will inquire about it. The check which is presented, he will ask to the drawer that the particular check is presented which is issued by you, and the amount is the huge amount. Then whether it is issued by you or not, he will authenticate by the inquiry that has to be done. Now, in India, to give protections to the paying banker, section 85 of the Negotiable Instruments Act 1881 as amended by the Amendment Act of 1934 lays down what is the protections is granted under section 85 of the Negotiable Instruments Act to the paying banker. Let us see. Let me allow to read out the provisions. Subsection 1 of section 85 says, where a check payable to order purpose to be endorsed by or on behalf of the payee, the drawee is discharged by payment in due course. And subsection 2 further says, where a check is originally expressed to be payable to the bearer, the drawee is discharged by payment in due course to the bearer thereof, notwithstanding any endorsement, whether in full or in blank appearing thereon, and notwithstanding that any such endorsement purpose to restrict or exclude further negotiation. Again I am repeating it. Subsection 1 of section 85 which states that where a check payable to order purpose to be endorsed by or on behalf of the payee, the drawee is discharged by payment in due course. And subsection 2 further states that where a check is originally expressed to be payable to the bearer, the drawer is discharged by payment in due course to the bearer thereof, notwithstanding any endorsement whether in full or in blank appearing thereon, and notwithstanding that any such endorsement purpose to restrict or exclude further negotiation. It's very important provisions has been made as my concern to get the statutory protections by the paying banker. The first and foremost thing which I like to mention here, that where the check payable to order purpose to be endorsed by or on behalf of the payee, that means the persons who is presenting, the bank believe that is either in form of, you can say, the endorse, it is through the endorse, or it is handed over directly by the maker to that persons. He will believe, and on the basis of that, the drawee here is the banker. The banker discharged by the payment in due course, because he has no choice to stop the payment. So, in that way, that he has to, what he has to do, that he has to discharge his duty. And the second circumstances, when we will see the subsection 2, and it says where a check is originally expressed to be payable to the bearer, the drawee is discharged by payment in due course to the bearer thereof, notwithstanding any endorsement whether in full or in blank appearing thereon, and notwithstanding that any such endorsement purpose to restrict or exclude further negotiation. So, there is the endorsement can be made in the various way, whether it is a full or in blank. When the endorsement is making with the signatures of the endorser, we are calling it the full, and by mentioning the name, and sometime he will put his signature and he will hand it over that, then we are calling it is the blank endorsement. So, in whatever it appears, it does not matter. If it is presented, the drawee bank will believe that the persons who is presenting the check for the payment, he is entitled and there is no any kind of the defect of him. Only one thing you might have experienced, that what the bank will do, the bank will taking the signature at the back of the instruments, and that sufficient as far as concerned for the paying banker, that he will ensure that we have made payment to such person. Now, the fourth one which is talking about the statutory protections when can be claimed. Now, there the circumstances which have been laid down, that where the payment or you can say the protections by the paying banker under section 85 which we have discussed, where this can be claimed. So, statutory protections when can be claimed, there are the two conditions which have been made. The first, the paying banker can claim the statutory protections only on fulfillment of two conditions. That means, again as I have told you that there is a duty towards the paying banker. The paying banker has to perform accordingly. In absence of that, the paying banker is not entitled to get any kind of, you can say, the relief under the Negotiable Instruments Act. The protections which is granted under section 85 of the Act, that is not available to the paying banker if he is not complying these two conditions. What are the conditions? The first condition is that the endorsement must be regular, although the endorsement is forged. The endorsement must be regular, although the endorsement is forged, and the second one is the payment must be in due course. Now what do you mean by the payment in due course? That has given, as I have already mentioned before you, that is section 10. But let me allow to read out what says the section 10. Before a banker debits his customer's account with the check paid, he has to ensure that he satisfies all the requirements for payment in due course to avail the statutory protections. That means he has to act according to the provisions of section 10 of the Act. Section 10 of the Negotiable Instruments Act 1881 defines payment in due course as, let me allow to read out the provisions. Payment in due course means payment in accordance with the apparent tenor of the instrument in good faith and without negligence to any person in possession thereof under circumstances which do not afford a reasonable ground for relieving that he is not entitled to receive payment of the amount therein mentioned. The first things, the two things which I like to express before you. The one thing, as I have told you, that the apparent tenor of the instrument in good faith. Apparent tenor here means how it appears when other persons is presenting, and if you find that there is the date, their amount is mismatched, that there is alteration. So, in that circumstances, it must not be paid by the banker. And the second one is without negligence to any person in possession thereof under any circumstances which do not afford a reasonable ground for believing that he is not entitled to receive payment of the amount therein mentioned. As I have already mentioned with you, I have shared that it is a very crucial task which is available in the hand of the banker, that to determine the entitlement, whether the person is entitled or not. So, some sort of, you can say, the precautions can be taken by the banker, which I am not saying that the 100% it can be eliminate that problems, but it can be reduced if the bank will start to ask certain things. So, naturally then you will find that the persons, you will find that he is not in a position to answer. In that way, it might be some extent we can say check whether the person is entitled or not. But as I have already mentioned that most of the time the bank what the doing that he is getting the signature overleaf of the instrument that is sufficient as far as concerned that he has taken precautions before making payment, as that he will treated that he is the right persons and he is entitled to get payment under section 10 of the act. A payment may be considered to be due course only if the following conditions are satisfied. But as my concern that when we are explaining the section 10, then we can find these 4 things. The number 1 is in accordance with the apparent tenor, as I have already discussed with you that in what forms the it appears. The second one is the payment in good faith and without negligence. The payment must be made in good faith. That means as far as your understanding, the person is entitled to get that payment and there is no any kind of the negligence. And the third thing is payment to a person who is entitled to receive payment, that must be the person is to the holder. And the last one is endorsed by pay or his order, that the endorsement plays a very significant role. Now, the checks drawn payable to bearer and purporting to have been endorsed. Now, the protections is available to the bearer check. Section 85 subsection 2 of the Negotiable Instruments Act 1881 states that where a check is originally expressed to be payable to bearer, the drawee is discharged by payment in due course to the bearer thereof, notwithstanding any endorsement whether in full or in blank appearing thereon, and notwithstanding that any such endorsement purpose to the restrict or exclude further negotiation. Now, the protections is in case of the cross check. As we have seen that the cross check means it is payment will be made through the collecting banker, but the paying banker is under an obligation because the collecting banker send a check to collect the amount from the other bank, means where the customer's account lies. So, the protections in case of the cross check, what is that? The paying banker is under an obligation to make payment of the cross checks as per instructions of the drawer conveyed through the crossing. The paying banker, having paid a cross check in due course, has a right to debit the drawer's account, and for doing so, he cannot be charged either by the drawer or by a holder in due course, even if the amount does not reach to the true owner thereof. This protection is provided to the paying banker under section 128 of the Negotiable Instruments Act, which lays down the provisions is stating that where the banker on whom a cross check is drawn has paid to the same in due course, the banker paying the check, and in case such check has come to the hands of the payee, the drawer thereof shall respectively be entitled to same rights and be placed in the same position in all respects as they would respectively be entitled to and placed in if the amount of the check had been paid to and received by the true owner. The banker making payment of a cross check is given protections under section 128 of the Negotiable Instruments Act 1881 if he makes the payment after fulfilling the following requirements. What are the conditions when he is making, or he has to fulfill these conditions? There are the 2 conditions has been made. The one condition, first condition is that he has made payment in due course according to the section 10, that is in good faith and without negligence and according to the apparent tenor of the check. And the second condition is that the payment has been made in accordance with the requirement of the crossing under section 126, that is through any banker in case of general crossing and through the specified banker in case of a special crossing, which we have already discussed. Again, I would like to make you clear that when we are talking about the protections which have been granted to the paying banker in case of the cross check, the bankers, when he is making the payment of the cross check, that the protections which he granted under section 128 of the Negotiable Instruments Act 1881, if he makes the payment after fulfilling the following 2 requirements. The first requirement, as we have already discussed, that he has made payment in due course according to the section 10, that is in good faith and without negligence, and according to the apparent tenor of the check. And the second one is that the payment has been made in accordance with the requirement of the crossing under section 126, that is through any banker in case of the general crossing and through the specified banker in case of a special crossing. So, when the check is presented before the paying banker has to ensure that whether the check has been presented in the right way or not. In general cases, there is no problem, but in case of the specified cases, that the check must be submitted to the specified branch. The paying banker is discharged from his obligations on a cross check irrespective of the fact that the payment was received by the collecting banker on behalf of the persons other than the true owner. The protections on which the alterations is not apparent in the circumstances, if the bankers is trying to do that, and if the bank is unable to find out any kind of the alterations which he made, the bankers cannot be held liable, but the bankers has to prove that he has taken utmost care. The protections for the drafts drawn by office of the banker on another officer of the same bank, that protections is available under section 85A of the Negotiable Instruments Act. The protections in case of the forgery, if the check is forged with the signature of the customer, the paying banker should refuse to honor it. If he honors it, no statutory protections can be afforded to him. If the signatures of the payees endorsees are made, the banker is liable. Section 85 of the Negotiable Instruments Act 1881 gives the statutory protection to the paying banker in such cases. Now, the statutory protections is available in case of the payment is made by the mistake, but the other persons according to section 72 of the Contract Act 1872, which reads, a persons to whom money has been paid or anything delivered by the mistake or under coercion must repay or return it. But the bankers has to be very cautious that when he is making the payment, he has to ensure that the payment should not be made mistakenly. Otherwise, it is very difficult to recover. But under the section 70 of the Contract Act, we have read where it is talking about a persons to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. The money received malified is recoverable under the paying bankers if the amount which has been mistake, in fact the mistake, or in you can say that if the person receiving payment is aware of the fact that he is not entitled to the same, the payer's right to claim the amount from his is indisputable. So, on the other hand, if the payer is subject to the duty against a payee to inform him of the true estate of the account, which is in effect a duty not to make mistake or fact in that regard, and the payee's position is altered, the money cannot be recoverable back. Mistake as far as that I have already discussed with you, so I am not going in the details that part. That there are the modernizations in the payments is using in the technology, as we know that through the electronics means the automated teller machines, the smart cards and the credit cards, all the things are covered under the Information Technology Act, and as my question that if any kind of the deficiency in service is found, the paying banker is not responsible in that way, but the remedy is available under the Consumer Protections Act. With these remarks, that as I have told you that the collecting banker and the paying banker, the protections which has been available, statutory protections which are available in both the banker, that is subject to the duty which is imposed under this act, unless and until they are fulfilling that conditions or they are discharging their duties, their rights which is, or you can say the statutory protections which is available or which is granted under the Negotiable Instruments Act, that cannot avail or that cannot be exercised. So, it is the utmost duty towards the paying banker or the collecting banker that first they have to act according to the provisions of the act. If they are acting accordingly, then the statutory protections which is granted under the Negotiable Instruments Act, that can be availed or protections can be exercised by the paying banker or the collecting banker, whoever may be. Thank you very much.